Hi, I'm Sunny. Welcome to LawMax Injury Lawyers. Today we are talking about the statute of limitations in the state of California for sexual assault cases. What defines a sexual assault? The term sexual assault means any non-consensual sex act prescribed by federal, tribal, or state law, including when the victim lacks capacity to consent, meaning minors. Californians are subject to nearly 1,200 new laws in 2022, covering everything from gun control to minimum wage. Among the most noteworthy new laws are those pertaining to the statute of limitations for California sex crimes. In October, Governor Gavin Newsom signed into law 2 new bills that amend the rights of sexual assault victims in the state of California. Both of these laws are now in effect. The Assembly Bill 1510 and Assembly Bill 218. The Assembly Bill 1510 was drafted in response to reports of decades-long sexual assaults committed by Dr. George Tyndall, a doctor at the University of Southern California. He treated students on the campus, and he was reportedly abusing the trust of nearly 400 female student patients. He committed sexual assault by subjecting these patients to unnecessary and improper gynecological treatments over a period of 27 years. A second USC physician, Dr. Dennis Kelly, received similar allegations in 2019 from no fewer than 48 gay and bisexual male former students. After learning of their assault, most of these victims were barred from seeking damages due to the statute of limitations in California. But in September 2018, the California State Assembly unanimously voted on the Assembly Bill of 1510. Childhood sexual assault victims often don't realize the full impact of their abuse for years or even decades. For many, the revelation comes long after the legal statute of limitations has already passed. Prior to October 2019, child sexual assault victims had only until the age of 26 to file a lawsuit. If they realized as adults that their psychological distress was caused by childhood sexual abuse, they would be granted an additional 3 years from that time to file a suit. With AB 218, now in effect as of January 2020, child sexual assault victims now have an additional 14 years. For those who discover the abuse later in life, the extended California statute of limitations is now 5 years instead of 3. In addition, courts can triple the amount of damages awarded to a victim in the event of an attempted cover-up by the institution who perpetuated these crimes. Thank you for joining us, LawMax Injury Attorneys. The reason that we have brought this to your attention today is because of the recent allegations against the Saddleback Valley School District. In the LA Times Weekly, there was an article, and this sexual abuse survivor did bring her abuse to the attention of the school board, and it was routinely ignored or downplayed. So the idea of a statute of limitations seemed important to me because this abuse occurred when she was in high school over 20 years ago. So if something is concerning you or your child or family member or loved one, just know that because of these 2 new laws that have been in effect in California, you now have significant room to file a sexual assault claim in the state of California. If you or your child or loved one or friend or somebody who was a minor and experienced sexual abuse at the hands of a professional or administrator, someone that they've trusted, just know that this victim has now ample room to file a claim under these 2 new passed laws. There's more time and there's more room to receive compensation for pain and suffering, and also increased compensation for damages that they can receive. So you do have rights, and you do have many more options than were afforded in the past. Thank you for joining us at LawMax Injury Attorneys.